recommendation for listing a rate petition record. Similar matter has been pending before this.
Go to the registry. It's a new matter.
New matter, Lordship. Similar matter.
New matter.
Yes, Lordship.
When did you file it?
Lordship. Yes, Lordship. Similar matter one fixed 184.
84.
So kindly
84.
84.
May applicable. But prepare for listing a writ petition for admission here. Any date of
Registry.
So
All old matters go to the registry. Tomorrow.
Please, I am on behalf of AM Khan, Lordship.
Huh?
I am on behalf of AM Khan, Lordship. He is out of station, Lordship. But I will take next week, Lordship, any date.
M. Khan? Mr. A.R. Bhuyan appeared last time.
Yes, Lordship.
So
AM
who is
Khan
going
is-
to, why won't Mr. Bhuyan is here?
Yes, Lordship.
Then let him come.
AM Khan is engaged that Mr. Bhair.
Huh?
AM Khan is engaged,
So
Mr.
Mr. A.R. Bhuyan is not going to appear anymore.
No, Lordship. He will appear, Lordship. Now,
Then let him come. Let him come.
Lordship,
You cannot play around like this. Yes, do it for the other side.
Lordship.
Yes.
Pass over for time being, Lordship.
Yes. Let him come.
Yes.
Let Mr. A.R. Bhuyan come.
Okay.
67. Where is where is your spokesman, your leading lawyer?
Lakes Mallet. Mallet, last order Mallet. I had also got talked with him Mallet. Mallet, so far as we are concerned, Mallet, we are agreeable to the proposal, but subject to only two things, Mallet. One, Mallet, that they should consider cases on merits, Mallet, number one. And secondly, Mallet, they must,
They will consider on merits, naturally, and as per the rulings of the Supreme Court,
Mallet,
judgments of the Supreme Court and High Court.
Mallet, as per the policy, Mallet, and also explain their part of delay, because all these cases, Mallet, are attributed. because
You see, you cannot have such conditions. Otherwise, if you are one, will decide the issue. They want to file affidavit in all the writ petitions. We'll ask them to file.
Because
We'll take
otherwise,
it up
Mallet,
on-
Mallet, I understand. Otherwise, Mallet, if they don't explain their part of delay, Mallet, because all these cases.
No, Mr.
point
Kausar,
to the delay, Mallet.
that is the truth. I cannot tell them how it should be decided. They can decide it, and then you always have the liberty of challenging it. How can I say, no, you cannot, your limits of consideration should be confined to this? How can I? When you see, there are different types of writ petitions here.
I understand.
There are some writ petitions which have been, death occurred in 20 years ago, 25 years ago, 30 years also. Then there are some cases where the mother had filed application that has been rejected. Now the son has filed.
Well, those are cases.
So how can I give such a blanket order? How can I paint all the cases with one brush?
That is.
That is there. So the only thing I can do is, if you are agreeable, I can tell them, you decide on merit, and keeping in view all the judgments of the Supreme Court and the High Court and the various guidelines laid down.
So then, what should we take it
That's
after
all.
some time? But again, after some time.
That's the only thing that can be
Well,
decided.
then after some time.
Otherwise, if you want, we
My
go.
lord, in this case, my lord will grant us 4 weeks time. We will file affidavit in each case. That is the stand of the government. My lord. That is my instruction. I'm supposed to, my lord, place with your lordship. My lord, so
Otherwise,
your
the
lordship, we will file affidavits in each and every case. We want to fight tooth and nail.
No, it's their liberty. They want to fight. They want to fight within that's point. Their point. So that's not the issue. Like, if they want to fight, they could have fought, my lord. They have like, argued the matter. Now they say that's a different issue. I'm not going in that. Our prayer, what should we think after some time?
Because this is the only matter that is
understand.
really listed.
And
Look, y'all, because you see, your cases are diverse.
I understand that.
Different cases are here, all different types. There are some cases where the DLC has rejected without challenging the DLC rejection. Or while challenging the DLC rejection, you have also challenged the 18924 on OM. So those things are there.
As per merit and as per the policy.
Huh?
As per merit, my lord.
As per merit and as per the decision, that's all. Now, is it okay with you? Is that offer still standing or not? Is gone?
My lord. Learned AG has already, my lord, it's on record. What is there on record, my lord?
Hmm.
I am going by that only.
Okay. So
Think-
they are agreeable to it.
Fine.
Only one thing, Mr. MK,
Only apprehension is there, my lord. My lord, referring to Tiwari, they'll say these are all facts. That's
well,
why-
that I cannot help it. That is the risk you have to take.
Because, my lord, they may not touch upon the delay on their part. That is.
And I'm not going to go into. You see, your cases are so diverse in nature. So many different types of cases are here. Like I was just telling them, there are cases in which the DLC has rejected. In some, the SLC has also rejected. So whether those persons have the right to even challenge the OM dated 18/9/24 unless the rejection of their applications is set aside. You see, there are so there are many issues.
Their lordship is-
So I cannot, it is very difficult to give a blanket condition.
My lord, I appreciate, my lord, I
I
understand.
have to leave it entirely to them. You have got the liberty to challenge subsequently. That is a different thing.
My lord,
I understand your
Only
apprehension.
what, my lord, I am worried is this is when your lordship says as per, my lord, latest decision of the honorable Supreme Court.
No,
my lord.
I will say as per, I'll say by taking into account. They can do. Okay, I will not say that also.
Yes.
I will not say
is
that
what I am
also.
saying. My lord, they let them decide on the basis of their merit.
But then once I don't say that, then you'll say that, look, it amounts to saying that that Deborah Brata Saikya cannot be
On merit,
considered.
on merit.
My lord, can a read court, my lord, direct that we should not follow Supreme Court's order?
Correct.
Does read
No,
court
my
have
lord,
that, my
is
lord?
it required that the court should say you follow?
No, I have to clarify because there is, you see, it's a double-edged weapon on both sides. It is a weapon, no doubt, for them to use. They can use it. But on the other hand, you will also say, it was clarified that this since the OM would not be applicable, and as the OM has provided for this Deborah Bhatta Tiwari judgment that they cannot use it. So we have to clarify that aspect. No doubt about it.
That will be, my lord, another set of procedure.
I leave it up to you all. If
My lord will just peruse the last order, my lord, what learned AG has.
no, I know. You see, the thing is that they are also worried because in there's a very high likelihood of you using Deborah Brata Tiwari in most of the cases, if not all. I cannot help. Unfortunately, it is a proposal made by them. You are free to accept or you are free to reject. And then we have to go into
Each and every.
then we'd have to go into each and every case one by one. And where I am quite sure at least 50% will go.
My lord, there are so many cases of minor. My lord,
Forget minors.
don't,
There are cases where there are more than one writ petitioner filing one writ petition. No dates, nothing is there.
Yes.
Now those will have to be divided, filed separate. I mean, there are different types of cases.
Yes, my lord, there are also cases when a person died in 1990, my lord, this case has been considered in 2024 and things happened.
Could be. And there are cases where it has been rejected.
Yes.
And they are challenging the 18/9/24 24 OM, while their target should have been the rejection of their application first. Then only they can challenge the 18,924. So there are many aspects to this. I cannot uncover each and every layer in this.
And if they decide on the basis of merit, my lord, whatever other observation you are watching, take, my lord, of merit, let it be there, let them decide. They can take reports to any.
Yeah, they can.
They can find out.
You see,
Freedom.
we cannot bar them. It's a Supreme Court. Who is this High Court
My
judge
lord.
saying that you cannot
So if
apply
the
this
word
Supreme
merit
Court?
is there, my lord, we are.
And neither can you say that.
So if the word on merit is there, my lord, irrespective of whether.
On merit and by taking into account the various guidelines and the judgments of the various courts.
Yes, sir.
So far, my lord, in fact, on the last occasion after this proposal came from the country advocate general, my lord, I asked my juniors because I am appearing on 4 or 5 cases. So I asked if something given in writing. Nobody has given in writing, my lord. So
I will write all of their names.
Fine.
Okay. Okay, right. Okay, one by one. Huh? Now, serial number 1. I have got to. Who is for item number 1? Huh? Mr. What is your name? F.A. Laskar. You write down also, right? Mr. F.A. Laskar appears for the petitioners in serial number 1. Then which one?
131,
Just a minute. 131,
32,
32,
36,
36.
and 42, man.
No, 36, your name is not there.
I have signed in the college moment.
Yes, right.
Madam.
And 42.
42, man.
Okay. Okay. Then number 2, who is there? K. Mira. Mr. K. Mira appears for serial number 2
At 17.
and 70. And 70. Okay, then Mr. F.U. Barbuya appears for serial number 3. That's all. No other. Only one matter.
Challenge the speaking order. Earlier directions given by the whole court to consider the case in other department.
Okay, no problem, no problem. Okay, no problem. Then Mr. M.K. Chaudhary, number 4.
I think number 4, 8,
Four, tell me.
4, 8, 38.
4, 8.
There is no 8 is not mine, my lord.
Oh, 8 is not yours. Just a minute.
38, 39, 40.
Just a minute. 4, 38, 44, 38, 39, 40,
50.
50, 55, 56, and 58. 58 also. Mr. M.K. Chaudhary, you are at
Yes.
58 also.
50.
Your name is there. Okay. Is it? No, sorry, this is provincialization. 58 is 58 is different. 58 is provincialization. Okay, till 56 only. Till 56. Then next will be Mr. N. Hossain. Or the number 5. Serial number 5.
Item 5,
Item 5. Your
N. Hussain,
Mr. N. Hossain. Item 5. What else?
46, 49,
46,
49.
49. Okay, then wait. And serially. You have to come one by one. No jumping the queue. Item 6 will be S.B. Chaudhary. Miss S.B. Chaudhary,
Item number 6,
6, 7,
7, 20.
20, 30 and
22.
22. That's all?
Yes.
That's all? Next will be Mr. Ayalam. Correspondent number 8. Serial number 8.
Serial number 8 and 43, my lord.
43. 43. Then next, Mr. A.M. Barbuya
Yes, my lord.
for 9,
9, 15,
15,
34,
34,
37,
37,
45,
45.
and supply 67.
Huh?
And supply 67.
67, supply 67, huh? Then next, Mr. K. Mazumdar. Number 10, serial number 10. That's all. Okay, next.
M. Kulihan.
For serial number 11,
24,
24,
25,
25,
26,
26,
and 52.
52. Okay. Next. Mr. P.K. Munir,
My lord. For
number
item
12,
12, 13 and 33.
13 and 33. Okay, next. N. Sharma for 14. And that's all. Okay, I think the others.
But I appear for 27.
No, where? You're for 16 is there. Wait, you're not there. Who is for item 16? A. Mohammed.
Yes, the item 16,
16,
18,
18,
19,
19,
21.
21. What about this 23?
23.
N. Hussein was there. N. Hussein is for item 5. We have said 23 also.
Yes,
N.
sir.
Hussein.
Yes.
N. Hussein. Just look at the beginning. 5, 46, 49. We did not, you did not mention
23.
23 also you put, huh? N. Hussein.
20.
Then item 27, M. Data.
27, 35, and 54.
27, 35 and
54.
54. Then N.J. Khataniar or J. Singh or K.K. Handik, anyone? Please call N.J. Khataniar, Miss. Okay, N.J. Khataniar. That's right, huh? For 28, 28. Only that. Then R.A. Chowdhury.
Okay, he is not available today.
Yeah, so R.A. Mazumdar.
R.M. Mazumdar, your lordship,
R.A. Mazumdar
Twen-
for 29.
and 51.
Of 29 and 51. Okay. Then S.B. Laskar. Where is he?
Port number 19 or 2.
19.
Item 30 and 41.
Okay, so we'll put his name or your name?
His name,
Miss S.B. Laskar for 30 and
41 or 2.
41. Tell him to come here after he finishes. S.B. Laskar for just a minute. Which one is it? 30 or 40. Let him appear. Huh? 36 to be already done. 36 is DH. Already done. So now we've got to go to 44. I.H. Barbuya or R. Raj Khoa. Not here. Huh? Oh, no, I need them. No. Let me see this item 44. Let me see if this can be separated. No, DLC has recommended, SLC has not considered. We'll put him out. Naturally, he wants consideration. Uh, so item 44, IH Barbuya. Then 47, B Purkaista or JP Barwa. Can you call him Mr. B Purkaista? Or otherwise we'll have to decide. Give me 47. Same out here. DLC has recommended, SLC has not considered. So I think he will also want. He has to want. Yeah, you're Mr. JP Barwa. Okay, so we'll put him. JP Barwa for serial number 47. That's all, only 47.
Yeah.
Nothing else, no? So, you are agreeable to the proposal that the government will consider your application on merit, correct? Okay, next, item 48, H Das or D Barwa. Here the SLC is also rejected. DLC reject, SSC is rejected. So he will want it naturally. Huh? Last order is that. For is that in item 48. Okay. If you can call him here, is that. Then next is M. Ahmed or IH Laskar. Item 53. Mr. Khataniar. We have said that you have also accepted the proposal. Correct. We just wanted to clarify. SLC has rejected, so I'm quite sure he wants. But rejected due to delay, long delay, 14 years. Okay. What else? They have accepted. Okay, Mr. M. Ahmed. Let's see who was the last M. Ahmed. M. Ahmed for item 53. Huh? Yes. Can you call him? Anyone knows? Otherwise, Riganko, can you call him?
We are just discussing that another round of litigation is we are.
100%. 100%. Lawyers are not complaining because another set of instructions. If you look at the bright side. So this order will affect only those cases which are in the court as on today. As on today. Because there might be some cases filed today, we don't know. So might have been filed also. So those cases as on today, other cases will be decided on that.
Because some cases already filed long back, Miller.
I said all cases that are in existence in the court as on today.
As on,
As on today.
Miller, I have filed already 2 cases, Miller, which is pending, Miller. Along with the same.
No, what you can do is, all those pending cases that are there, you please give the number to him,
Yes.
make a mention memo, we will list it accordingly.
Yes, Miller. Yeah.
Within, by tomorrow or the after, we'll list everything everything will,
Yes,
and
yes.
we'll dispose it.
Yes.
Okay, you give, everyone give a mention memo
Yes,
to him.
Tomorrow I am giving.
You give a mention memo, we'll fix the particular date, we'll finish it.
I want matter is
Tomorrow, then that's okay. Why if
I
it's
can
visit tomorrow, it's okay. No problem. Okay, right. Where is the? Huh? Has been recommended. Then why are you challenging? So that'll be different issue. That is the problem, no? There's so many diverse cases. And
I had a similar case, though it's not in this list, madam. In that, the government will took time to file an affidavit, where both SLC and DLC is recommended, and the matter is with the finance department. So this is not, this case is not here with this list, madam. That's been taken up in our.
number one, we are connect the order.
now what to do in those cases?
Let it be tagged with the other one. File will segregate this case.
Huh?
This particular case, file will segregate.
Huh?
So there is nothing to.
Can be tagged with the.
There is nothing to decide there. That has to go as per its own merit.
It is to go on its own merit.
Yes. So item
Item 33.
33, you take it out, huh? Item 33, you take it out.
Let it be tagged with WPC 59
Item 33, list this matter along with WPC number
5293 of 24.
5293 of 24. It is the case of the petitioner that in the said 2 cases, the DLC and SLC have recommended the compassionate appointment of the petitioner. And as such, the impugned OM dated 18/9/2024 could not come in the way of the recommendation made by the SS. Huh? List the matter when? That was when was it listed? Okay, list this matter. After vacation, after vacation. I know that matter has no date. After vacation. This is the matter after vacation. Huh? Item 33. Okay. Yes, yes, yes. That's the one you mentioned. Item 33 is gone.
28-4.
Huh?
28-4.
28/4.
It may not be my matter. There are other matters also there. Oh, well, then sorry, it's my.
List the matter 28/4.
28-4.
So that issue, we will not go into the merits of the OM. We will just say that this OM cannot come in the way of the recommendation because that has already been done. Similarly, there are decisions of this court that it should be considered by the DLs. Now, whether the OM can override the decision of the court, so that's another aspect. You see, that's why there are different layers to these cases. Okay, right. Heard also all these names. Then also heard Mr. Who's appearing?
Pilot, I am
I
appearing.
will not put the AG's name will not be here, no?
Pilot, but
Okay, anyway, I'll reflect this order.
reflect this order.
Okay. Heard Mr. R. Dhar, Learned Counsel for
Additional senior government advocate.
the additional central government, additional
Senior
senior government advocate for the state of Assam. Mr.
I'll be for, but
B. Kaushik appears for the Department of School Education. That's all.
and
yeah,
head doctor for revenue.
And Mr. S. Datta for the Revenue Department. Full stop. Miss S. Sharma for the Health Department. Mr. Pegu, you're there? Why not? Okay, right. All the writ petitions have paid for setting aside the office memorandum dated 18/9/2024 issued by the government of Assam, Personnel B Department by which the scheme for compassionate appointment has been done away with for all those family members of government servants who died in harness prior to 1/4/2017. The office memorandum dated 18/9/2020 has been issued in complete supersession of the compassionate appointment policy notified by the Personnel B Department, Government of Assam, by OM number ABP full stop 50/2006/PT/182 dated 1/6/2015 and other related personnel department office memorandum pertaining to the said compassionate appointment policy. The basic objective of next para, the basic objective of all the petitioners in all the writ petitions is that the state government should consider the petitioner's application for compassionate appointment on merit and not and not reject the petitioner's application with one stroke of the pen by referring to the impugned poem dated 18/9/2024. On considering the various writ petitions submitted by the petitioner, it is found that the is that it is found that the cases of the petitioner allude to allude different facts and circumstances which require this court to go into the various reasons given in the various writ petition for directing the respondents to consider the petitioner's application for compassionate appointment on merit. The next para, the various the writ petitions are different in facts and some of the examples of the writ petition for which they pray that the same should be considered. They pray that the compassionate appointment application should be considered on merit are as follows. 1, 2, 3, 4, 5, 6, 7, wait for that. Full stop. Next para. The above being said, no, next para. No. On the other hand, it is the case of the state respondents that there is no infirmity with the OM dated 18/9/2020 issued by the government of Assam, Personnel B Department. As the same has been made in pursuant to the judgment of the Supreme Court in the case of State of West Bengal versus Debra Brata Tiwari and others. Civil Appeal number 8842-8855 of 2020, which was decided on 3/3/2020. Next one. Without going further into the issue as to whether the OM, the impugned OM dated 18/9/2024 should be set aside. So don't say it should be set aside. Is bad in law or not? Baba. It would be no this court is it would be proper to refer to the proposal made by the learned AG Assam, which is to the effect that all pending applications before the SLC and DLC would be decided by the authorities without taking recourse to the oppugned poem dated 18/9/2024. What about those that are not pending before the SLC and DLC? All cases, no?
My lord, those are not pending for your lordship, my lord. We don't know, my lord.
No, no. Because this order, I was just looking at it, it says that where is the
Which is to affect all the pending applications for the FFC and DFC decided by the authorities without taking report to the issue.
so it's this order is not complete because not only the SLC, DLC, you see some cases the court has directed that it should be considered. So it is not pending before them. So those also will have to be considered.
Yes.
And those,
Where
so all those cases that are pending in the court,
pending in the court, my lord.
pending in the court, okay?
Pending in the court, but again, my lord, the thing is that they, it will be difficult even for the authorities, even, my lord, those are pending. Two cases are
No,
pending.
no, we will see as on today, as on today. So all as on today only.
Pilot will direct only those cases to be considered pilot. Even authorities who own the pilot which are pending and they will
Okay.
consider it will be difficult pilot.
Okay. No, we will say as on today, but we are going to mention all those cases that are going to be there.
Whatever is
All those cases are going to be mentioned in this order. No, because why I'm saying,
Are there.
why I'm saying pending is because tomorrow and the after some other cases which are there but which are not listed today will be coming up.
pilot.
That also will be this order will cover. But if you're also say pending,
Ah.
cases which are pending, well, that to be also considered. If you're also can say where there are directions of the court to place it before the DLC or SLC. Because those are not placed before the DLC or SLC. There may be a category of cases where there are directions which again they have approached this honorable court that despite there are directions it is not been.
No, that is one. And there are cases where the SLC has rejected or the DLC has rejected. Those are there also. Those are there also. There are different cases here.
But if SLC has rejected, obviously you are not going to have the validity of the order.
That is what. That is what. So this is going to create a Pandora's box. Because there are some cases in which like the mother had applied. It was rejected. And instead of the mother challenging her rejection, the son has applied. Now, those cases we cannot allow.
Those possibly require a independent certification.
Those require independent education. So that is what to dispose of this matter.
Difficult.
This is-
And there are some cases of minors pilot. Those are even barred pilot. There is a different judgment of this code. Minors pilot cannot apply for. When they attain maturity, there are judgments of this honorable court following the court judgment.
There they can pass out it.
Huh?
There they can pass out it that it's not cannot pass the thing. That those cases help with the future or
Pilot will give us liberty following with the law pilot. That was to the pilot.
but basic
Which
basic
market?
apprehension of this specifications are that there is a way, therefore there
So where we can clarify that wherever the what happens when the DSC is rejected?
At a very initial stage.
Now, unless we set aside those rejection orders, and they cannot consider.
Each and every order.
Each and every order will be set aside. Yes. They're going to cause problems.
And while setting aside the reason necessary, well, at least some reason necessary. on merit. Why it is rejected? Sir? Pilot only, what I understand, there is a report is only pilot. It is proposal valid. Only that consideration pilot will pass an order. So in that way, pilot will not touch all the orders. We will again reconsider.
Huh?
We will again, it's like
You'll reconsider all the cases affect.
pilot will not exactly reconsider pilot, which are pending, one time pilot will consider. That is what it is saying,
Which are pending in the court.
pending in the.
Or my lord, file fees today, my lord, or previously.
Okay, yes, you can take the decision. That's it.
Thereafter, my lord, there may be some PLC has rejected a case, but if that rejection is status, but there is no question of applying that poem. So that rejection was independently done on that.
Correct,
Some merit.
correct. No, but then what happens is, I have noticed one case where the DLC has rejected now the DLC, if it rejected, supposing we say that the rejection is bad in law, then y'all, I think there is some case there that the DLC has not considered due to this Debra Bhatta Tiwari. That is there also.
This order will follow. But majority of these
Like it
cases
was
are,
not-
majority of these cases are that PLC either has determined that it is pending before LC, but the apprehension is the meantime that whoever has come. So their cases will be considered in terms of, and they will be
What about those that have been rejected? So we'll say that all will be reconsidered.
rejected of their round of seven.
If a case is already rejected on merit side, earlier matter. Suppose no vacancy.
Those cases, my lord, if the rejection was right, my lord, they rejected again. If the rejection was, my lord, not proposed, they reconsidered pass out. So reconsideration will not put them in difficulty. And there might be one of two cases where my lord, it has to come back again, my lord, saying that this.
We can make it clear in the order that this order has not been made by take, by by considering each and every case on the merits, on its merit. And as such, the same is again left to the authorities
Yes.
to reconsider as they feel fit and proper.
Yes.
That will do.
है ना?
Let's take care of.
A lot of useless cases are here also.
Yes,
Right.
Some of the lawyers will be knowing some their cases are not
no,
good.
but in series, in one writ petition, 10 writ petition. No data ballot. When the
I know. There is that.
They have to be in threshold.
There is no data. I saw one repetition with two repetitioners. Nothing about when their fathers died. No particulars are there. Anyway, so you all can take a decision. Okay, what have I said? It will be proper to refer to the proposal made by the AGSM, which is to the effect that all pending writ petitions which have put a challenge, which are pending in this court, challenging the impugned notification dated 18/9/2024, shall be considered by the authorities, by the concerned authorities on merit, and by taking into account the various guidelines for compassionate appointment that were applicable in the state of Assam prior to 1/4/2017 and the various decisions passed by the Supreme Court and the High Court. Next paragraph. The counsels for the respondent, the counsels for the counsels for all the petitioners which are reflected in the foregoing paragraph have all submitted that they are agreeable to the proposal made by the learned AG Assam, and as such do not make a challenge, do not wish to press a challenge to the impugned OM dated 18/9/2024 any longer. Correct? In view of the agreement between the counsels for the parties, all the writ petitions that are pending in the High Court, which have put to challenge the impugned OM dated 18/9/2024, shall be reverted back to the concerned state government department, to the concerned authorities to be considered. No, so as to, what have I said? No, are being decided as follows. Rama. Number one, all the applications for compassionate appointment submitted by the petitioner shall be considered and disposed of by the concerned DLC/SLC on merit by taking into consideration the various guidelines laid down by the state government for compassionate appointment prior to 1/7/2017. 1/4/2017. And by the judgments of the Honorable Supreme Court and this court. Next paragraph. The entire process for considering the various applications for compassionate appointment and the decision to be taken by the concerned authorities should be completed within a period of 6 months from the date of receipt of the certified copy of this order by the concerned deputy commissioner or by the concerned district commissioner of the various districts, or the if it pertains to the DLC, or the chief secretary to the government of Assam, if the matter pertains to, so if the matter is to be decided by DSS. Correct? Is it okay?
Actually, it is spelled chairman DLC and chairman SS.
Okay, chief secretary, government of Assam / chairman SLC. No, I'm saying it because it has to go to them. No, we cannot give it to the committee. So it has to go to particular person. And that DC, no, DC, you make it / chairman DLC. Anything else?
Yes.
Acha, it is made clear. in view of the agreement made between the parties, this court has not gone into the merits of any of the cases that is being disposed of by way of this order. And as such, the no, and as such, the applications for compassionate appointment should be disposed of by the concerned authorities on merit as they deem it fit and proper.
I probably but last sentence, they'll dispose of with a speaking order to communicate with communication.
Okay, the decision taken by the concerned authorities should be by way of a speaking order. And they should communicate the same.
My lord, taking order, basically, we.
No, they should, no, they say this, whatever I said, the authorities, should be communicated.
Not speaking order, my lord. We have minutes, my lord.
Okay.
Was it minutes to decide?
Uh-huh.
Because if we have to pass speaking order. for-
Correct.
it will be very difficult.
Correct. Should,
What-
Leap over for 10.
should, no, don't say speaking order. Should be, the decision to be taken by the concerned authority should be by way, should be based on the basis of reason, and the same should be communicated to the petitioner thereafter. Petitioners thereafter. Huh? Anything else? The writ petitions are accordingly disposed of. I will put all the list of different circumstances under which the writ petitions have been filed. The categories, yes. Whatever I know it's not going to be exhaustive enough, but then I'll attempt to at least put in a few.
Although my lord, your lordship,
Acha. Okay. Who is for the PHE?
no, one sentence, my lord, your lordship.
Yes.
Your lordship has, although my lord quoted what the Advocate General stated, that my lord that OM will not be. taken.
Acha, one more thing.
That last line, my lord, that should.
The respondent authorities. Now, in view of the agreement made between the parties, the authorities, while deciding the applications for compassionate appointment, cannot take recourse to the OM dated 18/9/2024, though the judgment provided therein by the Supreme Court, that is Debar Bhata Saikya Supra, can be considered by the concerned authorities.
Okay.
Acha, PHE, Mr. I Kalita appears for the PHE. Handloom, who appears for the handloom?
My lord, I.
Mr. They don't need to say that. Okay, Mr. No need. What about PWD irrigation? No need. For everyone.
I am there.
AH and BTC Forest. BTC.
My friend is.
Mr. S. Bora appears for the BTC. Forest.
My lord, I am there. Sorry.
Mr.
I call it.
I Kalita for Forest. PHE and Forest. Veterinary department, you.
My lord, veterinary.
Veterinary.
Veterinary, my lord, my lord, M. Potoki is the council, my lord.
N. Kotaki. MS.
MS.
MS Patoki appears for the AH and Veterinary department. Otherwise, if your AG was here, he would have covered everyone. Unfortunately, he is not.
See, my lord, I can, my lord, as an additional senior, I can always, my lord, check for any department.
Oh, okay. That's then why did we?
It's okay, my lord.
Okay. So, see you after 6 months.
No, my lord. In between, there will be some contempt. That part also is there, my lord.
No, that will be only after 6 months.
Everything
It cannot be 6 months time is given.
Yes, my lord.
So that's why.
Good.
Now you keep up the good relationship with your clients. You give a mention memo. Everyone you can give mention memos, but just tell him that it's for that. But it should be a challenge to that 18, 9, 24. If there's no challenge, then no. Yeah, some of y'all have got very bad cases, but y'all have challenged the OM, so y'all are lucky. We'll fix it on Monday. If you give let it come in one go. You give it by today, tomorrow, so that we'll fix it by Monday. All of them. Or even Saturday also. No, Saturday they won't come.
Saturday, Monday.
Monday.
I will come, but
You give. Acha, we have said that all pending cases as on today. As on today, huh? As on today, and give the date, today's date.
my lord has taken a Herculean task, my lord. It was a very big going into all the cases. It's a Herculean task, my lord. Deeply of that. My lord take a lot of faith.
No, but nothing to decide.
I think you depend, my
Good for me. I'm relaxed now.
lord. 57.
Item?
Kindly peruse the order dated 18/3/2025.
Yes, one thing I want to know, first of all. So Viva voice and computer typing test not held till now. Then then one thing you said that the post of the junior assistant, which had been advertised.
Yes.
Now that had been filled up.
Subsequently, she resigned.
No, filled up on the basis of some other advertisement.
Other
Yes. Some other advertisement dated
One
1/3/2000.
2022.
1/3/2022. Then now with this advertisement, so on the basis of that, someone joined.
Yes.
When?
Pubali Dotto.
Huh?
Pubali Dotto was joined.
Where is that? Where do you get that? Where do you get that Pubali Data? Where? Which page?
In our affidavit, my lord, page 90, my lord.
90.
Her resignation, 90.
90.
Yes. Annexure 4. Her resignation letter.
And
'87 is the appointment order.
Page?
87, running page 87 is the appointment order dated 25/5/2023.
25/5/23.
23. And
I'm joined on 1/6/2023, page 89, Annex 3.
One
subsequently,
six eighty 23.
1/6/2023.
Yes, then resigned on.
resigned my lord on 10/5/2024, page 9.
So you see, the thing is that the earlier advertisement, now that has been superseded by the subsequent advertisement.
Yes.
Correct?
Yes.
Where is that advertisement 1/3/22? Let us see.
But that advertisement is not on record. This is the advertisement.
You did not participate in this advertisement.
About I don't know. Because the centrally this advertisement was issued without given any specific school's name, the post name. As a whole, that has been issued. But this advertisement issued pursuant to an act, my lord. The act itself says
And where is the other advertisement?
the another advertisement is
The first one, 2019.
but
That was
page
stopped by
33.
Deputy Commissioner.
Page 33 of the writ petition.
Is this a government school?
Yes, yes. But what has happened earlier, as per the rules, my lord, the managing committee is the authority for selection of the candidate. And these subsequent advertisement has been issued pursuant to the Assam Direct Recruitment Commission for Analogous Posts in Class 3 and Class 4 Act 2021. And that act, I have already given your lordship in on it is on record. And section 21 clearly says that any recruitment process for which the advertisement have been issued or which is at any stage of the recruitment shall be completed as per the existing provision under which the advertisement were made.
No, maybe, but the fact remains that this is of 2019.
Yes.
Then after that, there has been a subsequent advertisement.
But the subsequent advertisement issued pursuant to this act is very clear
So
that the pending any advertisement, any recruitment process is pending. That has been done pursuant to the earlier advertisement issued for some
show me which page are you?
Malad, I have given the act, Malad. That is on record. Act is just this.
Yes. I have not seen the act.
Section 21.
Correct. But you see, this has been finished. So you see, the 2019 advertisement now has been eclipsed by the advertisement of 22, and that has run its course. Appointment has been made, nothing survived. Supreme Court has time and again said that once advertisement issued, post filled up, if that person resigns or whatever, then a new process has taken place. You cannot go back to the old process which has started in 2019 and which never was completed. You see, because the subsequent advertisement has now superseded the earlier one. Implied.
But without cancelling the earlier
Maybe,
advertisement,
but then
that was pending before this honorable court, madam.
no case.
And this is not for the fault on the part of the petition.
Correct, but no case. Yes, where is the
Actually,
judgment?
Act itself is says so much. That if any pending proceedings is there.
No, no, no.
That earlier order.
But you see, that any pending process will depend upon if that process has been cancelled, then that process cannot be said to be pending because
Well, that has
this
no
advertisement has impliedly cancelled the other one.
Well,
Has impliedly
but-
cancelled it.
But
Maybe
have
that
not-
word is not there, but has impliedly cancelled.
But in the some Supreme Court judgment mallet itself says,
Ah.
best course of action, even the amendment of the rules itself. Best course of action, they cancel the earlier one, but they have not cancelled it.
And then this person had joined this post in 23. You did not challenge.
Yes, I have challenged her appointment order.
Ah.
I have challenged,
Okay.
but subsequently she resigned.
It is-
That's why this honorable court has said that in fact, I have challenged her appointment.
Okay, you challenge her.
Just you join, then immediately challenge, and
Okay,
after
you
receiving the
challenge her.
notice, yes, after
But,
receiving the
that
notice,
advertisement was
ballot,
not challenged.
this is
That
W,
advertisement was not
WBC
challenged,
number
so it is-
6554 2020. These are tagged with this 6554 2020. I have challenged her appointment. Immediately after the challenge ballot, she resigned.
In that petition, he has challenged only the appointment order dated 25/5/2023, but that advertisement was not sent.
At the advertisement, the petitioner cannot challenge it because centrally that has been advertised without specifying any post ballot. So how can he challenge it?
This post that has been advertised Is a grateful post.
No, no, grade 3.
Grade 3. Under what provision of law?
Well, this is as present has been made, my lord, the Assam Secondary Education Provincial Service through 2020, 2003.
Huh? 2003, let us see the rule. Yes, sir. Huh? Page?
Malad,
2003, no?
2003 rules, page 372. Number 363.
368, ma'am.
363. Rule 4, method of recruitment to the post of junior assistant. Rule 4 is the method of recruitment.
Yes.
For rule 8, 4 mal the school committee to be.
Yes, Mr. Sharma. What is to be done?
Another thing, he has not challenged the advertisement, madam. And earlier advertisement was stopped and it is superseded by that advertisement, new advertisement, madam.
You have not challenged that.
No. What? How can it be challenged, madam? What? Without any specifying any post.
Madam.
So this is advertisement centrally for all over Assam. How can he challenge it? Even in the additional affidavit of the inspector of school said that I have signed the appointment order without specifying any post. Subsequently, director has been allotted. There is no indication that this advertisement has been issued to the
All
particular.
this particular. Yes. Why don't you complete the selection process?
Now, my lord, grade 3 posts and grade 2 and grade 3 posts are all are filled up by my lord. All recruitment process will be done by the my lord Assam direct recruit under the Assam Direct Recruitment Commission, man.
Maybe, but then this rule says that all pending process to be completed at this thing, rule 21, act, is it an act? Section 21, 21(1). Any recruitment process for which advertisement has been issued and which is the stage of recruitment shall be completed. But I think you have to challenge the advertisement that it cannot uh, relate to the post for which you have advertised. That portion of it, put that. Otherwise, it will not be correct because now they have been given the permission to do it. So that clarification will have to be made with regard to this. How many posts?
So many posts.
New advertisement, it is my lord.
The numbers of
Eliminate
thousands.
The post has been filled up. Its
Uh,
post has been filled up.
That post was not filled up as because that incumbent has already
Has
resigned.
resigned.
And until and unless my lord, this advertisement is not cancelled, then it will still exist, my lord. And then new advertisement. So. And he has not challenged this new advertisement, my lord.
But in the new advertisement, you have not said that this post is also included.
That's the problem.
So his post is still vacant.
Yes.
Then you complete the
On the
process
resignation of that new incumbent.
after resignation.
Yes.
Why did she resign?
Due to her personal purpose.
Huh?
Due to her personal purpose. Yes.
Due to a personal problem.
So what about Malad?
What does your affidavit say? What does your affidavit say?
In my annexure 4, page 90. With due respect, I have the honor to inform you
Which,
that
Mr. Counsel, which affidavit? Whose affidavit?
my lord inspector of school, my lord, it
This phone number?
is my lord, former inspector of school, my lord. So,
But,
Saidullah Khan, my lord.
Malad, the page 81, para 3 of their episode. Inspector. Para 4 regarding the resignation.
I think you make a challenge that advertisement only for out of abundant caution. That it will not, it cannot be cannot relate to your school or whatever in view of this, in view of this law, in view of this section 21. Just make that. So having slight reservation. You make an additional affidavit.
Yes.
For additional.
Yes.
Mr. R. Islam, counsel for the petitioner, is granted 2 weeks time to file an
By an
additional affidavit.
interlocutory
Huh?
application also. Malad.
Huh?
By an interlocutory application also.
How? Interlocutory. Why?
Challenging this advertisement.
Can do whatever.
Yes.
Just say on the fair offense, so matters are there for 2 weeks. Huh?
Matlab.
Yes.
May I please, your lord? My lord, two instructions, my lord, we are required to be placed, my lord. One is the minutes of the, my lord, district level scrutiny committee. My lord, what has happened?
You are
my lord,
supposed to produce the resolution number 2, yes.
my, that is the, my lord, we have applied to RTI, it is not giving to me. RTI has been made, that record is with me. My learned friend, my lord, if make an effort, can be, record can be called for. Lord,
It is your case.
that is correct, my lord, but sometime, my lord, it becomes very difficult to obtain certain records. So the minutes are not being provided. And secondly, my lord, in the last round of litigation, my lord, it had been disposed of, my lord, in the motion stage without the issuing notice, my lord. That's why some facts we could not place at that particular time.
Either are you placing facts here?
My lord,
You have not placed facts here either.
no, my lord, yes, my lord, the provincialization order we are required to annex, but my lord, we have made the statement that my service has already been provincialized.
No, you see,
My lord.
If your service has been provincialized, why are you filing the writ petition?
Because, my lord, it is that they are now attempting to reopen my provincial license. If my lord.
Huh? They are attempting to
reopen and
attempting to reopen, and reopening is different.
But
Let us see your writ petition.
My
Your
lord, my
prayer,
friend-
your prayer,
My lord, may kindly see the MP.
your
order.
prayer. Let us
My-
see your prayer.
My lord. That, my lord, starts at page
23.
23, my lord.
Yes.
The impugn resolution for setting aside for circular, my lord, we are praying the impugn resolution number 2 dated. So and so adopted by the. district court,
Without knowing the contents of the resolution, you are asking for setting it aside. What is the contents of the
Next
resolution?
time, my lord, we have prayed
No, no.
for.
How can you challenge something without knowing what it is?
No, my lord, basing on this resolution, the impugn communication has been made. My lord, may kindly have a look, my lord. The.
Yes.
My lord, at page 50, annexure 12, my lord. With page 50, annexure 12, my lord.
Yes.
This is from the district elementary to the director, my lord.
Yes.
With reference to the subject cited above, I have the honor to inform you that as per the direction of the Department of School Education Assam, so and so, the district level committee Gwalpara was scheduled on so and so in connection with so and so, Shahjahan Ali Mandal and Gwalpara. Accordingly, the DLC Gwalpara has been examined the proposal for provincialization of staff in respect of KB Memorial MEM, and as per resolution number 2 of the minutes of the meeting dated, it is found that Shahjahan Ali Mandal is senior than the Shahidul Islam respondent number 6, and also instructed to the DO to submit the proposal for provincialization as per seniority. So,
So what is wrong?
Milord,
What is wrong? They found the
No, my lord,
respondent senior.
because, my lord, if this honorable court, my lord may be pleased to find that this honorable court, while dispose of the petition, my lord, we were required to be heard, my lord.
No, okay, you can have another hearing with them if you want.
No, my lord, the seniority is in dispute, my lord.
No, you see, it's not that.
Seniority is in
You
dispute.
give me the other writ petition.
My lord,
You see, your service was provincialized
my lord.
as SME teacher, as a social
Tutor.
science teacher.
No, as a tutor, my
No, forget that.
lord.
Forget that tutor. Learned counsel for submitted the respondent number 6, that is the petitioner. You are a SME teacher,
My lord,
correct?
my lord.
Is a SME teacher of so. And that the respondent number 6 herein is
Social-
a social science
Social
teacher,
science.
social studies teacher.
My lord.
And it is a social studies teacher whose service has to be regularized, not yours. Has to be provincialized. And this is clear from the observation made in this judgment, in this order. It says here, there is no dispute with regard to this fact.
Lord, the judgment which has been, my lord, the order which has been passed, my lord, may I be permitted to read, my lord?
Yes,
Uh, The writ petition is filed by the petitioner being agreed by the recommendation of the district scrutiny committee recommending the respondent number 6. So now I am the petitioner.
yes.
In the subject of social studies in respect of KB Memorial ME Madrasa in the district of Gwalpara, Mr. So learned counsel submitted the petitioner was appointed as an assistant teacher in the subject of social studies, and the private respondent number 6 was also appointed in the same school on so. The learned counsel for the petitioner further submitted the respondent number 6 is an Assamese language teacher of the KB Memorial ME Madrasa. There is no dispute.
There
with
is
regard
no
to this fact.
dispute with regard to
My
this
lord,
fact.
my lord, it is their contention has been recorded.
No, it is not that. There is no dispute.
There is no dispute with
Okay,
regard to the fact.
let me record your submission. Were you a Assamese subject teacher or a social studies teacher? Let me be very, you tell me.
My lord,
No, you tell me. You tell me
my lord,
whether you are a Assamese subject teacher or a social studies teacher.
because my lord, what has happened in the why?
No, not because this answer.
No, my lord, I am answering, my lord.
Ah.
I am duty bound to answer, my
Yes.
lord. My lord, what has happened, my lord, initially when I was appointed as an headmaster, my lord, in the DIAS data, I had been shown that I am teaching all the subjects. being in the capacity of the headmaster.
Then
Now, my lord, then when the provincialization has been carried out, then there is a, my lord, some change in the subject category. My lord. That's why all these disputes.
in the dial data, how are you shown?
My lord, that dias data has not been, my lord, is available on record also. My lord, that statement is very difficult to make at this moment. My lord. So, my lord, may I pray, my lord, one of my conducting, my lord, my colleague, my lord, who is, my lord, out of station for some personal day, can it be taken up on Monday
Why Monday?
or any other date as per the
Why not tomorrow?
tomorrow he may not be available. That's fine.
No. What will happen if he takes up on Monday? What is he going to
Because,
say?
Lord, I can place the fact properly in a correct manner. Even my lordship may dismiss my petition also. I am not.
No,
on
that is probably that's the way it's going to go.
No, my lord.
But then,
the
if you
correct fact should be recorded, my lord. If
Correct.
wrong.
you see, correct fact will be recorded when you produce the fact. When you challenge the resolution number 2
that is
without annexing resolution number 2 or the contents of the same being
That is required to
shown
be
in the
known.
repetition, you're the one who's playing hide and seek with facts.
My lord,
How can you just challenge without knowing the contents?
my lord, hide and seek, I am not, my lord.
You see, I'll tell you why.
Why?
I'll tell you why.
Only my mistake is that, my lord, on the order which has been passed by by this honorable court, my lord, in the last round of
No,
litigation.
let me tell you
Why?
that well, anyway,
Monday, my lord, maybe please to take up. That resolution is
right. Right, Mr. A.R. Borbuya, learned counsel for the petitioner.
only Bhuya, my lord.
A.R.
Only Bhuya, my lord, not for.
No, A.R. Buya, learned
Right.
counsel for the petitioner, who submits that the matter may be listed on Monday.
What?
When he will produce the impugned resolution number 2 dated 23/7/2024. So, sir, on considering the interim prayer made by the petitioner, this court is of the view that no interim stay can be granted in respect of resolution number 2 of the DLSC Golpara dated 23/7/2024, inasmuch as the same has not been annexed to the writ petition and neither the contents of the said resolution number 2 has been reflected in the writ petition.
But,
Naturally, you produce it, we'll see.
Lord, may I pray?
This is the matter on Monday.
My friend can also have in the record, my lord.
You do it first. You do it.
Well. Oblige.
Yeah, people don't.
Page for a week time.
For what?
I know it.
File the affidavit. You're the petitioner. You have filed the writ petition. What more do you want to file?
Also, phone number is clear. File the affidavit. We need to reply.
Look, Mr. Counsel, what is your prayer in the writ petition?
To provincialize the
To provincialize. Under what act?
process, it's 2011 Act, ultra fast. There, after this, created by the review. That involves also the legislative review by the state. That
Look, Mr. Counsel, it said if the legislature so decides. The only way your service can be provincialized now is under the 2017 Act. Your service cannot be considered under the 2011.
Yes, well, that part is accepted.
Then,
Totally in their affidavit, in the response number.
if you want provincialization of your service, why don't you go to the educational tribunal? What is the educational tribunal for? There's an alternative remedy available. Huh?
To which they may,
Oh, what are you going to say in your affidavit?
but I got the instruction from my
Who's your senior?
what the MH Choudhury.
Where is he?
Out of
Huh?
some difficulty
M.H. Chowdhury
in it.
or M.K. Chowdhury?
Oh,
M.K.
okay,
Chowdhury,
okay.
hai.
Yeah.
He was here this
No,
morning.
no.
No, what? Huh? Different M.K. Chowdhury.
It's out of state.
He's out of state. Different M.K. Chowdhury. So there are two senior advocates, M.K. Chowdhury.
Yes.
There are two M.K. Chowdhurys. Okay. Is there two M.K. Chowdhurys? No, out here it is M.K. Chowdhury. Then in the orders passed by this court, it says here Mr. M.K. Chowdhury. M.K. Chowdhury and okay, the next one there is Mr. M.H. Chowdhury. Okay, right. On the prayer of the petitioner counsel, 2 weeks time is granted to file affidavit in reply to the affidavit filed by the respondent. This is the matter of the 2 weeks.
Ticketing about the minimum base scale of the picture.
Yes, where is the affidavit?
Lordship may be 15 days for your time. Immediately after vacation, is because
Mr. N.J. Khatta, Mr.
due from England.
Deepamanu is granted 10 days time to file affidavit in position. List the matter. Give after opening. State after opening.
But that will be the last one. Lordship, can it be on 2020? Very clear that
Huh?
24 days.
You file it.
I learned this 23 matrix. It may be.
Initially, my lord, 7th of March 2025. I came Uttari of the appearing, my lord, I am saying because these unwell stay, my lord. There is a direction, my lord.
Huh?
There will be kindly see this last order, 7th of March 2025.
Pension, a provisional pension, not pension.
My instruction is, telephoning instruction, a provisional pension has been paid till February 2020. Entire amount has been. I have to take instruction. I have nothing.
Okay, right. Mr. S. Bora, Learned Counsel for the BTC submits that as per his instructions, provisional pension up to February 25 has been paid. Mr.
But so
A.
far.
Dekar, Learned Counsel for the petitioner submits that he needs to obtain his instructions with regard to the above submission made by Mr. S. Bora. Yes, madam. N. Sharma. S. Sharma appearing for Accountant General submits that she has got nothing to submit.
But our
Is it?
main prayer is also we are not getting the regular pension.
Submit that you're not going to file any affidavit. No affidavit required. Are you sure? Submit that the Accountant General has got no role to play in this matter.
But the prayer of the petitioner is he is not getting the regular pension.
Then
the
do
death
for
of
my
the
lord,
family.
original pension, regular pension, it will be
Provisional
respondable.
is the additional
No,
part.
fine.
What
Respondable
about the, what about the
Why aren't you paying
Regular
the
pension.
why aren't you paying the
Yes.
pension?
5 years have
Pension,
gone by? Let me talk. 5 years have also kindly appreciate since he is a grateful employee. He retired in the year 2020. Till date, they have not taken steps to
Why?
get
Pay the regular pension. Instruction is sitting, my lord. But the provisional pension has been paid, my lord. Yeah, later on, all the.
No, but then he doesn't want provisional pension. He wants regular pension.
One regular pension, my lord. Director of pension is the party one who will release the pension. All the paperwork has to be done by the BTC and sent it to director of pension.
Have you sent it to the Directorate of Pension?
That instruction is awaited, my lord, because I am.
5 years.
My lord, I am AP only for today, my lord. Only for today because my colleague, my lord, Hakim Mushari is out unwell, my lord. That's why I got the telephoning instruction as well.
Right. The council for the BTC shall, on by the next date, inform this court as to whether the regular pension, as to whether the proposal for regular pension payable to the petitioner has been submitted to the Directorate of
Concerned
Pension.
respondent, Lord.
Huh?
You may say concerned respondent.
It will be the Directorate.
But they may also
Okay,
say-
to the concerned respondent.
No.
The council for the BTC shall produce the forwarding letter issued by whom? Who has to make it?
The proposal should come from the district elementary division officer.
You shall propose the forwarding letter issued by the district elementary education officer,
Baksa.
comma, Baksa,
Yes, but
for payment of, no, for the,
finally,
with the, regarding the proposal for payment of regular pension to the petitioner. List the matter on, when?
First week of, well, after we do anything.
Why not next week?
Not next week, my lord. Let it be immediately after vacation, my lord. Let it be on 20,
Before
20,
vacation.
Huh? List the matter on
23rd, my lord.
23rd, 24th.
24th. Can it be on 21st? Apply. 63.
He's on lake. Thank you.
No, we'll wait.
Other book.
Item?
64 and 55.
Yes, what has happened to the appeal?
Malad, AP, I have seen, Malad, the filing number they have given.
That's the
But
last
till
time.
date, no mistake for condonation has been filed. That was under objection. After 5 years has gone, Malad, by the issuance of the order. Unfortunately, Malad, one of the petition already expired. And others are going to be retired. And these persons were appointed.
So who is, so Mr. SMP Chisti was supposed to be here. If they don't come, okay, we'll tell them to appear in person.
Not Malad Khataniya.
Huh?
Subsequently, he appeared on behalf of the respondent number 11.
No.
Khataniya, yes.
In 21/3/2025, SMT Chisti.
Yes, he
NJ
was
Khataniyar was
seconded.
earlier.
He was
Anyway,
seconded.
no point. We'll ask them for personal appearance.
Yes.
My lord, I am calling MJ Khatani.
You call whoever. Right. Heard, Mr.
R.
R. Islam. Learned counsel for the petitioner. Petitioner. They are both the same. No, different, but same order.
Yes,
Same
same
order.
common.
Learned counsel for the petitioner. So submit that in terms of the order dated 26/9/2019, passed in WPC 4447/2014,
And 4409/2014.
Huh?
4409/2014. Two by two written.
who repeated it?
Yes, common order.
And 4409/2014. The respondents were to make necessary verification in for release of the arrear salary of the petitioner Good stuff. Despite the contempt petition had been filed in the year 2020 due to non-compliance with the above order. Good stuff. It is seen that it is next para. It is seen in the order dated 21/3/2025 that the respondent that the state government has filed the state respondents the state government has filed an appeal against the order dated so past in so. And filing number 3512 of 2025 has been given to the said appeal. To the said appeal. This court, next para, this court in its order dated 21/3/2025 had directed Mr. SMT Kisti, Learned Counsel for the respondent, to provide the registration number of the application for condoning the delay in filing the appeal. However, Mr. SMT Kisti is not available.
For the time being, he is on late, my lord. Yes.
We have filed a interlocutory application for condonation of delay, my lord. That is real number
Right. Mr. Mr. N.J. Khatania, appearing for the respondent, submits that condonation of delay in filing the appeal has been filed on
it was filed yesterday, my lord, but I got the number today, my lord. 4166
has been filed yesterday is what it is, on 2/4/2025,
sorry, my lord, 34. Date of filing has been shown as 34, my lord.
3/4/2025, and the filing number is
4116/2025.
4116
4166
4166
2025,
2025,
and one is 4165/2025.
and the other is
4165/2025.
4165 2025. So what have you done? When are you going to ask for listing?
My lord, next week, my lord. I'll make a mention, my lord.
The next para, Mr. N.J. Khatania shall inform this court as to whether the as to when the said application is to be listed before the division bench. List the matter next week, Thursday.
9th, my lord. Obliged.
Matter.
Obliged.
Time being item 53. Anyway, we'll wait, we'll let him come with continue. No, this is the last item.
Lordship, in fact, in this matter,
No, I don't. I'll take it up as it is. So, yes, but
here in this matter, Mr. A.R. Savilta appears, Lordship, he is on leave and post for 5.
okay, we are waiting for him. Let him come. We'll be closing this off. Who is the counsel for the petition? What is their name?
Lordship. Petitioner apply for the post of executive producer. As per notice, July month, the month of July. Subsequently, the month of October, modifying the partial
The way the marks are to be given.
lots. I
And
want just
you have taken part in the written test. There was a written test.
no lots.
No test has been conducted.
Till now. My apprehension is that earlier as per notification,
It has to, yeah. So, any judgment?
check
You have got no judgment.
Supreme Court judgment Lord.
Which one? Tej Prakash.
Test Prakash Asaf.
Latest judgment. Para 52.
Lord.
Covered matter, Mr. Counsel. Constitution bench judgment. You see, but out here, this is not a question of eligibility criteria. This is only the manner in which marks are to be given. How does it affect you?
Yeah, right. Notification not held in executive.
Huh?
Only apprehension. Lord.
Apprehension, what apprehension? You see, there is no change in the eligibility criteria. It's only the manner in which the marks, the marks would be, are to be revised. The calculation of marks are to be revised. That's all. So he says that this case is covered by Tej Prakash.
No,
No.
that's it. But initially, because this is a pre-mission test. First of all, the director has to say that initially the process advertisement has been done.
Yeah.
The procedure has been changed.
Hmm.
The rule of the game has not.
Never changed.
So to that effect, Lordship, that if this is liable to be because there are only
The manner in which the marks are to be given, actually.
yes, that has been said, and it is the authority who can decide how they will select.
Any citation?
Yes, sir. Paragraph 30 of the in the judgment of the state of Uttar Pradesh versus Karunesh Kumar and others. Paragraph 32.
Paragraph 30.
32.
SCC is not here.
No, I did not get that.
SCC is not here, no?
I'm not telling the notification of letter notification, but I only appear earlier notification, I apply the post.
You want the earlier application to be applied. How does it affect you?
The process, is the.
How does it affect
Till
you?
now, not held in interview law.
Not held. What is the process going to be? Written examination or what?
No, interview marks.
Interview marks, that's all.
Interview marks, nothing.
Paragraph 30 তে নিচে clear আছে।
Only prayer
Paragraph
point.
30
Only prayer. I'm not telling them notification. I apply,
only
yes,
the
by
process is-
earlier notification. We have to appear.
The qualification, the basic qualification, etc. has not
I'm
been.
sorry, my lord. Rule of the game change after the game is over. This is the one.
The issue is basically this, as to whether the rules of the game have been changed or not.
Now you must kindly see my page 22. What is? What is?
Yes.
What is your page 22 on your right side? Second one is situation, second monthly and so forth. What's the put?
Yes.
The terms and conditions then. What's put by? We have detail. For concept. Qualification and selection procedure will be as per government notification November dated 24/1/20. That is page 17 and 19.
Where are you reading? Page 21, you said?
Page 20 and exact 2.
Page 20.
21. 21.
21. 21 is this NHK 2 years.
Newspaper copy.
Huh?
Newspaper copy.
The education qualification will be as per government office memorandum. And selection procedure, okay.
Okay, my lord, now that your lord will be available, 17, page 17,
Page 70.
that noted.
Yeah.
Then you have told it. That's 17, you almost 23, that delta 24, 122. Now kindly come to page 19.
Page 90.
Page,
Yeah.
page 1.
Yeah.
Post page number
Yeah.
4.
Yeah.
Number 4.
Yeah.
90% and above, you lost it.
They'll be given 30 marks.
30 marks.
Correct.
Now, they have changed by data subsequent notification, my lord, the page 22.
Yeah.
Page 20.
Yeah.
Page 22 says you lost
80% and above 30 marks.
50%.
So?
So that means some other candidate will come after the everything is over.
No. Just,
After I
just
have
give him
applied.
this. I think this is his copy. This is your take part. Now, according to you, this change of calculation of marks or the giving of marks is a change in the rules of the game. That is your case.
That is my case, my lord. So
Now-
numbers, my lord, I am having more than 90% mark.
Already interview held.
No, in fact, we have because of this sports. My
Interview not held. So where's the question of 90% mark?
lord,
At the time of submission.
once somebody allows 80%, that he will get 30%, automatically I will be, because so many countries are there. But because of some interest, matter, they have changed it to accommodate someone.
Okay, so all your mark sheets were submitted.
Everything, for everything over, last date is also over. Last date is the petition of file, thereafter this notification.
Not
Yo.
start.
Huh?
Interview not start.
But now interview based on
But this with this
Interview not start.
these marks are going to be given on the basis of the interview.
Yes, look.
Okay.
no, the education qualification.
Educational
It
qualification.
is academic mark, not interview.
Yeah.
This is academic mark.
Yes,
Academic.
Academic mark, Mr. Counsel.
Yes, no, so academic mark, they will verify everything. After verifying the candidates.
So as per the academic mark,
Yes.
he had 90%.
At below percent, many candidates applied for.
Huh?
Many candidates applied.
Correct.
So now in interview, this selection process has not been started.
Maybe.
So Lordship, whether this will amount to changing the rule of that, because it is the authority to decide what category, what type of candidate they require. So before the starting of the selection process. So that says that paragraph 32 says that only. Lordship. May I read that paragraph 32?
Huh?
May I
Yes,
read paragraph 32?
Not he's another judgment. He's given
So
this.
that part I have not seen.
Yes, I'm reading
Judgment will come only there are some ambiguous things are there.
No, let
That
us
is
see.
clear,
Let
that
us
is
see.
clear. Very clear.
You are relying also on Tej Prakash.
May I read that?
Yes.
The respondents have also placed reliance on the decision of this court in the case of K. Manjushri Tupra. However, in our considered view, the facts of the aforesaid decision are quite different from the present. A change was introduced for the first time after the entire process was over, based on the decision made by the full court for the cutoff. Secondly, it is not as if the private respondents were non-suited for participating in the recruitment process. Now, the principle governing changing the rules of game would not have any application when the change is with respect to selection process, but not the qualification or eligibility. Here we have not changed the eligibility or qualification. In other words, after the advertisement is made, followed by an application by a candidate with further progress, a rule cannot be brought in, disqualifying him to participate in the selection process. So we have not disqualified him. It is only in such cases the principal aforesaid will have an application, or else it will hamper the power of the employer to recruit a person suitable for it. So we have not changed, we have not debarred her. No basic eligibility criteria we have not changed. We have not changed nothing. Just process has been in our affidavit also I have clarified. And even after Lordship, the selection process is over also. Then also after that, the governing body will forward the documents to the director. And director will look into it. in terms of they compare, examine along with the advertisement also. That is also there. In such circumstances, it is even premature. In my affidavit, I have categorically
Because the selection process is not started.
not started, Lordship. Only interview that in between that the eligibility criteria we have not seen. She can always, he or she can always participate. So that does not mean that the rule of the game has been set. It is clear. And that even if, Lordship, I am certainly again, Lordship, that even if the Lordship, the selection process is over also, then also director will take its decision, final decision as per the rule 7 of the Lordship or education.
No, but then one thing, when you have made the selection process to be based on a certain circular, then aren't you bound by that?
Subsequently, we have Lordship, we have released another circular. Lordship.
Correct, but then that, you see, the advertisement was based on a particular circular, not on the subsequent circular.
Yes, Lordship, but
And that subsequent circular is after the last date of submission
yes,
of application, then
yes, Lord. But in the subsequent circular also, we have not changed the eligibility criteria or
maybe.
we have not barred the petitioner to appear in the interview or selection process. In my understanding, Lordship, that this paragraph says that on the process that may I read once again. The principle governing changing the rules of the game would not have any application when the change is with respect to selection process, but not the qualification or eligibility.
We are not qualification matter.
Yes.
Not
We
disqualification.
we have not changed. We have
No,
not.
that is, I am not on that. Not disqualification, question disqualification does not come. I am qualified, but question you are changing the, after the game is over, after the application was repeated.
No,
There is
you
only
see,
marks, no?
you see, Tej Prakash basically talks about
Qualification.
the change in the eligibility criteria.
Yes.
So eligibility criteria has not been changed.
Yes,
Not changed.
not. But we
Uh,
have included some person who
Is-
otherwise,
No, I included some person, that is not the issue. The eligibility criteria for submitting your
question.
candidature does not change.
that is not question. That was
Only thing is that the
Process.
method of selection
Process.
has been changed. Now, in regard to that, there is a earlier judgment of a Supreme Court in 2000, which says that once an advertisement has been issued on the basis of a circular operating at that relevant time, it cannot be changed. You have to.
Decision of 2020.
And what does the Supreme Court say? If there are two decisions, which one should be considered by the High Court? The earlier one or the later one?
But here, Lordship, since selection process has not started,
Maybe.
and the director has the authority now examine, that part is also there. That part has to also be considered as per law. In my affidavit, Lordship may page my affidavit at page 20.
Anyway, so this is some research will have to be done. Because it's not so easy.
Yeah.
One thing is clear that Tej Prakash does not seem to be applicable in this. But your decision also has a problem because the principle governing changing the rules of the game would not have any application when the change is with respect to selection process, but not on the qualification
Or
or eligibility, with the selection process. So selection process would not be applicable.
Yeah.
In other words, after the advertisement is made following by an application, a rule cannot be brought in disqualified. It is only in such cases. Only that it has said. It has not gone into the issue. But there is a Supreme Court judgment which has gone into the issue of when an advertisement is issued on the basis of a circular. The selection process has to continue in terms of that circular. And that is what is in the advertisement. The OM has been reflected. The OM date has been reflected. So it has said that it should be as per the OM, not as per a subsequent OM. So that is the case. So, I've heard you, I will decide. But it is not so simple as I thought.
But for your worship, it is simple, but for your worship.
No, 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 no.
What I am saying, my your worship. Notification has subject notification, specifically it is to be done as per the office memorandum points. The petition received everything there, but interview date was supposed to be fixed by the, but because of this one about post in whatever matter they have not had. Now, what they have done, my God, I am having more than 90%. Naturally, I left 30 marks.
Now another
Now-
10% might have.
Yeah, now they will come, they may also want to get this, but
Correct, correct.
this is the only problem.
This will change the entire,
Exactly. One mark
this
is
will
the-
lessen their chances of,
This is the only thing, but your worship,
am I right? Right, Mr. H.R.A. Chaudhary, the learned senior counsel for the petitioner. Assisted by Mr.
M. Alamgir.
Huh? Mr. M. Alamgir. Huh? Also heard Mr. A.R. Tawilda, learned counsel for the
Number 1 and 3.
1 and 3.
1 and 3.
1
And 3.
1 and 3. While Mr.
District Mayor on behalf of Mr. Ikumo.
Mr. Ritvik Guya appears on behalf of Mr. A. Chama, learned counsel for the UGC.
Respondent number
That's point number 2. Okay, right. Then this order dated 8/11/2024. Second paragraph, third paragraph. Fourth paragraph. Huh? Okay, right. In support, next para, in support of its submission that the rules of the game cannot be changed after the last date of submission of the application, the learned senior counsel has relied upon, the senior counsel for the petitioner has relied upon the judgment of the Supreme Court in the case of Tej Prakash Pathak and others versus Rajasthan High Court and others, 2025 2 SCC 1. Next para. Mr. A.R. Tabilda, the learned counsel for the respondents number 1 and 3, on the other hand, submits that the case of Tej Prakash Pathak Supra is not applicable to the facts of the present case, as the doctrine prescribing change of rules midway through the game, after the game is played, is not attracted to the facts of this case. He submits that in Tej Prakash Pathak Supra, the Supreme Court has held that after commencement of the recruiting process, the eligibility criteria cannot be altered. He submits that in the present case, it is not the eligibility criteria of the candidate that is being altered by the subsequent issuance of the OM dated 22/10/2024, what is being altered is the selection process, which is permissible in terms of the decision of the Supreme Court in the case of the state of Uttar Pradesh versus Karunesh Kumar and others, 2023 0 AIR bracket SC 52. Correct? I have heard the learned counsel for the fact. As can be seen from the submissions made by the counsel for the parties and the government made in their pleadings, the advertisement dated 2/7/2024. Calling for application for filling up the vacant post of assistant professor in English and one post of librarian was to be considered on the basis of the educational qualification and selection procedure provided under the Government Office Memorandum number AHE 239/2021 68 dated 24/1/2022. The last date for submission of applications in terms of the advertisement dated 2/7/2024 was was to be was what date?
15 days.
15 days, no,
Six.
was 17, that means 17/7/2024. Pusta. However, the selection procedure had been changed by the respondent authorities and they sought to they, they sought to conduct the selection process. They sought to conduct the selection process in terms of the office memorandum dated 22/10/2024. Huh?
It is partial modification. Okay.
Yeah, anyway, what is more? Okay, in partial, whatever I said. No, in terms of the office memorandum, so what is wrong? In terms of the office memorandum dated 22/10/2024, comma, as indicated in the foregoing paragraph. What is pertinent to be noted is that the OM dated 22/10/2024 has been issued after the last date of submission of the application by the candidate. Acha, one more thing you write. Mr. A.R. Tabinda, the learned counsel for the respondent 1 and 3, also submit that the selection process has not started till date. And as such, the writ petition is premature. That's it. Next. The question that is to be considered is whether the rules of the game have been changed by the respondent authorities by changing the selection process by way of the OM dated 22/10/2024, which is a partial modification of the earlier OM dated 24/1/2020. Next part. In the case of Tej Prakash Pathak and others versus Supra, the Constitution bench, no? How many? 3 judges or 5 judges? 5 judges, no? 5, I think.
Yes, yes, yes.
The Constitution Bench of the Supreme Court had held that after commencement of the recruiting process, the eligibility criteria is not to be altered because candidates, even if eligible under the altered criteria, might not apply by the last date under the belief that they are not eligible as per the advised criteria. Such alterations, such change, therefore deprives a person of the guarantee of equal opportunity in matters of public employment provided by Article 16 of the Constitution. The Constitution Bench thus held that the rules of the game cannot be changed after the commencement of the recruitment process, insofar as the eligibility criteria is concerned. A reading, no, however, however, the Supreme Court in para 52, no, in para 52, in para, wait, copy. Where, but there is a judgment which says that if any benchmark is set, the same should be stipulated before the commencement of the recruitment process. But if the extent, rules, or the advertisement inviting applications empower the competent authority to set benchmarks at different stages of the recruitment process, then such a benchmark may be set at any time before that stage is reached, so that neither the candidate nor the census is taken by. That is also there. Okay, whatever. No, cut that. A reading, no, the above would that show that while the eligibility criteria of a candidate cannot be changed after the last date of submission of an application, there does not appear to be any bar for changing the manner in which marks are to be provided to candidates by the state. Basically,
It's on the method of the law. It says that the partial modification of the government order in the higher education field to notify the following revision. Page 22.
Yes, yes, yes.
Revision in guideline for selection of institution.
Ah, yes, yes, yes. So this is also still process.
So same thing that the decision of they are revising the guidelines of the selection.
Process.
No. Try to revision the guidelines.
No, no, anyway, no, no, they don't know. They can. Anyway, like, in, I'm not going to dispose of those food anyway. You get me this judgment. 2000, 2008 PSC 724. Next para. In the case of uh, Karunesh Kumar Supra, the Supreme Court has held that the principle governing changing the rules of the game would not have any application when the change is with respect to selection process, but not on the qualification of eligibility. Full stop. In other words, after the advertisement is made, followed by an application by a candidate, a rule cannot be brought in, disqualifying him to participate in the selection process. It does tell that. So what was the change got to be done here?
Calculation of marks.
What was the change got to be done?
Rule of
This is the-
2015.
Huh?
In the selection of the Panchayat Lordship appointment for the Gram Panchayat Officer.
So what was the issue?
It was Lordship that 2015 rule was adopted initially Lordship. Then thereafter 2018 was referred to be given. Fact, Lordship, paragraph 4.
Right. Next. Correct.
It is another day, partner day. Please support, I think. Concentrate. Concentrate. The issue raised from the parties can. The parties are given some more time to produce, I think, in support of the. This is a matter, when. What to do? Huh? Interim is there, no? This is the matter. After the vacation, interim order to continue. Give it in. Oblige.